455. The department or the criminal violation of any statute relating to the practice of a profession regulated by the department or appropriate board to the proper prosecuting authority for prompt prosecution. Point 2278 restriction on disciplinary action for student loan default. Definitions. As used in this section, the term default means the failure to repay a student loan according to the terms agreed to in the promissory note. Delinquency means the failure to make a student loan payment when it is due. Student loan means a federal guaranteed or state guaranteed loan for the purposes of post-secondary education. Work conditional scholarship means an award of financial aid for a student to further his or her education, which imposes an obligation on the student to complete certain work-related requirements to receive or to continue receiving the scholarship. Student loan default. Delinquency. The department or a board may not suspend or revoke a license that it has issued to any person who is in default on or delinquent in the payment of his or her student loans solely on the basis of such default or delinquency. Work conditional scholarship default. The department or a board may not suspend or revoke a license that it has issued to any person who is in default on the satisfaction of the requirements of his or her work conditional scholarship solely on the basis of such default. 455.228 Unlicensed practice of a profession, cease and desist notice, civil penalty, enforcement, citations, allocation of monies collected. 1. When the department has probable cause to believe that any person not licensed by the department or the appropriate regulatory board within the department has violated any provision of this chapter or any statute that relates to the practice of a profession regulated by the department or any rule adopted pursuant thereto, the department may issue and deliver to such person a notice to cease and desist from such violation. In addition, the department may issue and deliver a notice to cease and desist to any person who aids and abets the unlicensed practice of a profession by employing such unlicensed person. The issuance of a notice to cease and desist shall not constitute agency action for which a hearing under SS 120.569 and 120.57 may be sought. For the purpose of enforcing a cease and desist notice, the department may file a proceeding in the name of the state seeking issuance of an injunction or a writ of mandamus against any person who violates any provisions of such notice. In addition to the foregoing remedies, the department may impose an administrative penalty not to exceed $5,000 per incident, pursuant to the provisions of Chapter 120, or may issue a citation pursuant to the provisions of subsection. If the department is required to seek enforcement of the notice for a penalty pursuant to S 120.569, it shall be entitled to collect its attorney's fees and costs, together with any cost of collection. In addition to or in lieu of any remedy provided in subsection, the department may seek the imposition of a civil penalty through the circuit court for any violation for which the department may issue a notice to cease and desist under subsection. The civil penalty shall be no less than $500 and no more than $5,000 for each offense. The court may also award to the prevailing party court costs and reasonable attorney fees and, in the event the department prevails, may also award reasonable costs of investigation. Notwithstanding the provisions of S 455.225, the department shall adopt rules to permit the issuance of citations for unlicensed practice of a profession. The citation shall be issued to the subject and shall contain the subject's name and any other information the department determines to be necessary to identify the subject, a brief factual statement, the sections of the law allegedly violated, and the penalty imposed. The citation must clearly state that the subject may choose, in lieu of accepting the citation, to follow the procedure under S 455.225, if the matter in the citation, the procedure set forth in S 455.225 must be followed. However, if the subject does not dispute the matter in the citation with the department within 30 days after the citation is served, the citation shall become a final order of the department. The penalty shall be a fine of not less than $500 or more than $5,000 or other conditions as established by rule. Each day that the unlicensed practice continues after issuance of a citation constitutes a separate violation. The department shall be entitled to recover the cost of investigation, in addition to any penalty provided according to department rule as part of the penalty levied pursuant to the citation. Service of a citation may be made by personal service or certified mail, restricted delivery to the subject at the subject's last known address. All fines, fees, and costs collected through the procedure set forth in this section shall be allocated to the professions in the manner provided for in S. 455-281 for the allocation of the fees assessed and collected to combat unlicensed practice of a profession. The provisions of this section apply only to the provisions of S. 455.217, acts administered by the department. In the Professional Practice Acts, in order to protect the public and to ensure a consumer-oriented department, it is the intent of the legislature that vigorous enforcement of regulation for all professional activities is a state priority. All enforcement costs should be covered by professions regulated by the department. Therefore, the department shall impose, upon initial licensure and each subsequent renewal, a special fee of $5 per licensee, in addition to all other fees imposed, to fund efforts to combat unlicensed activity. However, the department may not impose this special fee on a license renewal for any profession whose unlicensed activity account balance at the beginning of the fiscal year before the renewal totals more than twice the total of the expenditures for unlicensed activity enforcement efforts in the preceding 2 fiscal years. This waiver applies to all licensees within the profession. An assessment of the special fee may not begin or resume until the renewal cycle subject to the waiver has ended for all of the licensees in that profession. This waiver does not apply to a profession that has a deficit in its operating account or that is projected to have such a deficit in the next 5 fiscal years. Any profession regulated by the department, which offers services that are not subject to regulation when provided by an unlicensed person, may use funds in its unlicensed activity account to inform the public of such situation. The board with concurrence of the department, or the department when there is no board, may earmark $5 of the current licensure fee for this purpose, if such board or profession regulated by the department is not in a deficit and has a reasonable cash balance. A board or profession regulated by the department may authorize the transfer of funds from the operating fund account to the unlicensed activity account of that profession if the operating fund account is not in a deficit and has a reasonable cash balance. The department shall make direct charges to this fund by profession and may not allocate indirect overhead. The department shall seek board advice regarding enforcement methods and strategies prior to expenditure of funds. However, the department may, without board advice, allocate funds to cover the costs of continuing education compliance monitoring under S. 455-177. Revenues received from the department's efforts to enforce licensure provisions. The department shall include all financial and statistical data resulting from unlicensed activity enforcement and from continuing education compliance monitoring as separate categories in the quarterly management report provided for in S. 455.219. The department may not charge the account of any profession for the costs incurred on behalf of any other profession. With the concurrence of the applicable board and the department, any balance that remains in an unlicensed activity account at the end of a renewal cycle may be transferred to the operating fund account of that profession. 455.2285. Annual report concerning finances, administrative complaints, disciplinary actions, and recommendations. The department is directed to prepare and submit a report to the President of the Senate and Speaker of the House of Representatives by November 1 of each year. In addition to finances and any other information the legislature may require, the report shall include statistics and relevant information, profession by profession, detailing the revenues, expenditures, and cash balances for the prior year, and a review of the adequacy of existing fees. The number of complaints received and investigated, the number of findings of probable cause made, the number of findings of no probable cause made, the number of administrative complaints filed, the disposition of all administrative complaints, a description of disciplinary actions taken, a description of any effort by the department for any disciplinary cases under its jurisdiction to reduce or otherwise close any investigation or disciplinary proceeding not before the Division of Administrative Hearings under Chapter 120 or otherwise not completed within 1 year after the initial filing of a complaint under this chapter. The status of the development and implementation of rules providing for disciplinary guidelines pursuant to S 455.2273. Such recommendations for administrative and statutory changes necessary to facilitate efficient and cost-effective operation of the department and the various boards. 455.2286 Automated Information System. The department shall implement an automated information system for all certificate holders and registrants under Part 12 of Chapter 468, Chapter 471, Chapter 481, or Chapter 489. The system shall provide instant notification to local building departments and other interested parties regarding the status of the certification or registration. The provision of such information shall consist, at a minimum, of an indication of whether the certification or registration is active, of any current failure to meet the terms of any final action by a licensing authority, of any ongoing disciplinary cases that are subject to public disclosure, whether there are any outstanding fines, and of the reporting of any material violations pursuant to S 553.781. The system shall also retain information developed by the department and local governments on individuals found to be practicing or contracting without holding the applicable license, certification, or registration required by law. The system may be internet-based. 455.229 Public inspection of information required from applicants, exceptions, examination hearing. All information required by the department of any applicant shall be a public record and shall be open to public inspection pursuant to S 119.07, except financial information, medical information, school transcripts, examination questions, answers, papers, grades, and grading keys, which are confidential and exempt from S 119.7, and shall not be discussed with or made accessible to anyone except members of the board, the department, and staff thereof, who have a bona fide need to know such information. Any information supplied to the department by any other agency which is exempt from the provisions of Chapter 119 or is confidential shall remain exempt or confidential pursuant to applicable law while in the custody of the department. The department shall establish by rule the procedure by which an applicant and the applicant's attorney may review examination questions and answers. Examination questions and answers are not subject to discovery, but may be introduced into evidence and considered only in camera in any administrative proceeding under Chapter 120. If an administrative hearing is held, the department shall provide challenged examination questions and answers to the administrative law judge. The examination questions and answers provided at the hearing are confidential and exempt from S 119.07, unless invalidated by the administrative law judge. Unless an applicant notifies the department at least 5 days prior to an examination hearing of the applicant's inability to attend, or unless an applicant can demonstrate an extreme emergency for failing to attend, the department may require an applicant who fails to attend to pay reasonable attorney's fees, costs, and court costs of the department for the examination hearing. 455.232 Disclosure of confidential information. 1. No officer, employee, or person under contract with the department or any board therein, or any subject of an investigation shall convey knowledge or information to any person who is not lawfully entitled to such knowledge or information about any public meeting or public record, which at the time such knowledge or information is conveyed is exempt from the provisions of S 119.0, 119.001. S 119 provision of this section is guilty of a misdemeanor of the first degree. punishable as provided in S 775.082 or S 775.083, and may be subject to discipline pursuant to S 455.227. And, if applicable, shall be removed from office, employment, in any advertisement by a veterinarian of free or discounted fee or treatment by a person licensed under Chapter 474. The following statement shall appear in capital letters clearly distinguishable from the rest of the text. The person responsible for payment has a right to refuse to pay, cancel payment, or be reimbursed for payment for any other service, examination, or treatment that IS performed as a result of, and within 72 hours of responding to the advertisement for the free, discounted fee, or reduced fee service, examination, or treatment. However, the required statement shall not be necessary as an accompaniment to an advertisement of a licensed healthcare provider, defined by this section, if the advertisement appears in a classified directory, the primary purpose of which is to provide products and services at free, reduced, or discounted prices to consumers, and in which the statement prominently appears in at least one place. 455.242 Veterinarians. Disposition of records of deceased practitioners, or practitioners relocating or terminating practice. Each board created under the provisions of Chapter 474 shall provide by rule for the disposition, under that chapter, of the records that are in existence at the time the practitioner dies, terminates practice, or relocates and is no longer available, and which records pertain to the practitioner's patients. The rules shall provide that the records be retained for at least 2 years after the practitioner's death, termination of practice, or relocation. In the case of the death of the practitioner, the rules shall provide for the disposition of such records by the estate of the practitioner. 455.243 Authority to inspect. Duly authorized agents and employees of the department shall have the power to inspect in a lawful manner at all reasonable hours any establishment at which the services of a licensee authorized to prescribe controlled substances specified in Chapter 893 are offered, for the purpose of determining if any of the provisions of this chapter or any practice act of a profession or any rule adopted thereunder is being violated, or for the purpose of securing such other evidence as may be needed for prosecution. Or 45 Veterinarians. The department shall issue an emergency order suspending the license of any person licensed under Chapter 474 who pleads guilty to, is convicted or found guilty of, or who enters a plea of nolo contender to, regardless of adjudication, a felony under Chapter 409 or Chapter 893, or under 21 U.S.C. SS 801 to 970, or under 42 U.S.C. SS to 1395, 271. A licensee may practice a profession only if the licensee who practices a profession without its license is in violation of this section in S 455.227, and the department, when there is no board, may impose discipline on the licensee. Each board, when there is no board, shall permit a licensee to choose, at the time of licensure, renewal, an active or inactive status. Each board, or the department, when there is no board, shall, by rule, impose a fee for an inactive status license, which is no greater than the fee for an active status license. An inactive status licensee may change to active status at any time, provided the licensee meets all requirements for active status, pays any additional licensure fees necessary to equal those imposed on an active status. Licensee pays any applicable reactivation fees as set by the board or the department when there is no board, and meets all continuing education requirements as specified in this section. A licensee shall apply with a complete application, as defined by rule of the board or the department when there is no board, to renew an active or inactive status license before the license expires. Failure of a licensee to renew before the license expires shall cause the license to become delinquent in the license cycle following expiration. Failure by a delinquent status licensee to become active or inactive before the expiration of the current licensure cycle shall render the license void without any further action by the board or the department. The board or the department, if there is no board, shall by rule establish a reinstatement process for void licenses, notwithstanding the provisions of the Professional Practice Acts administered by the department. The department may, at its discretion, reinstate the license of an individual whose license has become void if the department determines that the individual failed to comply because of illness or economic hardship. The individual must apply to the department for reinstatement and pay an applicable fee in an amount determined by rule. The department shall require that such individual meet all continuing education requirements prescribed by law, pay appropriate licensing fees, and otherwise be eligible for renewal of licensure under this chapter. This subsection does not apply to individuals subject to regulation under Chapter 473. Notwithstanding the provisions of the Professional Practice Acts administered by the department, each board, or the department when there is no board, shall, by rule, impose an additional delinquency fee of $25 on a delinquent status licensee when such licensee applies for active or inactive status. Each board, or the department when there is no board, shall, by rule, impose an additional fee, not to exceed the biennial renewal fee for an active status license, for processing a licensee's request to change licensure status at any time other than at the beginning of a licensure cycle. Each board, or the department when there is no board, may, by rule, impose reasonable conditions, excluding full reexamination but including part of a national examination or a special purpose examination to assess current competency necessary to ensure that a licensee who has been on inactive status for more than 2 consecutive biennial licensure cycles and who applies for active status can practice with the care and skill sufficient to protect the health, safety, and welfare of the public. Reactivation requirements may differ depending on the length of time licensees are inactive. The cost to meet reactivation requirements shall be borne by licensees requesting reactivation. The board, or the department if there is no board, may not require an inactive or delinquent licensee, except for a licensee under Chapter 473 or Chapter 475, to complete more than one renewal cycle of continuing education to the status or a change in status of a licensee, or to enforce discipline previously imposed on a licensee for omissions committed by the licensee while holding a license, whether active, inactive, or delinquent. This section does not apply to a business establishment registered, permitted, or licensed by the department to do business, or to a person licensed, permitted, registered, or certified pursuant to Chapter 310 or Chapter 475. 455.273. Renewal and cancellation notices. At least 90 days before the end of a licensure cycle, the department shall forward a licensure renewal notification to an active or inactive licensee at the licensee's last known address of record or email address provided to the department. Forward a notice of pending cancellation of licensure to a delinquent status licensee at the licensee's last known address of record or email address provided to the department. 455.275. Address of record. Each licensee of the department is solely responsible for notifying the department in writing of the licensee's current mailing address, email address, and place of practice, as defined by rule of the board or the department when there is no board. A licensee's failure to notify the department of a change of address constitutes a violation of this section, and the licensee may be disciplined by the board or the department when there is no board. Notwithstanding any other provision of law, service by regular mail or email to a licensee's last known mailing address or email address of record with the department constitutes adequate and sufficient notice to the licensee for any official communication to the licensee by the board or the department, except when other service is required, pursuant to S 455.225. Notwithstanding any provision of law, when an administrative complaint is served on a licensee of the department shall provide service by regular mail to the licensee's last known address of record, by certified mail to the last known address of record, and, if possible, by email. If service, as provided in paragraph, does not provide the department with proof of service, the department shall call the last known telephone number of record and cause a short plain notice to the licensee to be posted on the front page of the department's website and shall send notice via email to all newspapers of general circulation and all news departments of broadcast network affiliates in the county of the licensee's last known address of record. 455.3 Management Privatization Act. This section shall be known by the popular name the Management Privatization Act. The purpose of this section is to create a model for contracting with nonprofit corporations to provide services for the regulation of Florida's professionals, which will ensure a consistent, effective application of regulatory provisions and appropriate budgetary oversight to achieve the most efficient use of public funds. Nonprofit corporations may be established pursuant to this section to provide administrative, examination, licensing, investigative, and prosecutorial services to any board created within the department pursuant to Chapter 20 in accordance with the provisions of this chapter and the applicable Practice Act. No additional entities may be created to provide these services. As used in this section, the term board means any board, commission, or council created within the department pursuant to Chapter 20. Corporation means any nonprofit corporation with which the department contracts pursuant to subsection. Department means the Department of Business and Professional Regulation. Contract manager means an employee of the department who serves as a liaison between the department, the board, and the corporation, and is responsible for ensuring that the police powers of the state are not exercised by the corporation, while also serving as the contract monitor. Business case means a needs assessment, financial feasibility study, and corporate financial model as specified in paragraph. Performance standards and measurable outcomes shall include, but not be limited to, timeliness and qualitative criteria for the activities specified in paragraph. Secretary means the Secretary of Business and Professional Regulation. Based upon the request of any board, the department is authorized to establish and contract with a nonprofit corporation to provide administrative, examination, licensing, investigative, and prosecutorial services to that board, in accordance with the provisions of this chapter and the applicable Practice Act, and as specified in a contract between the department and the corporation. The privatization request must contain a business case that includes a needs assessment and financial feasibility study performed by the board or an entity commissioned by a majority vote of the board. The needs assessment must contain specific performance standards and measurable outcomes and an evaluation of the department's current and projected performance in regard to those standards. The feasibility study must include the financial status of the board for the current fiscal year and the next 2 fiscal years. A financial model for the corporation must also be developed, which includes projected costs and expenses for the first 2 years of operation and specific performance standards and measurable outcomes. The business case for privatization shall be submitted by the board to the department for inclusion in its legislative budget request to the Executive Office of the Governor and the legislature pursuant to S. 216.023. The board shall proceed with the privatization only if such privatization is specifically authorized by general law. Any such corporation may hire staff as necessary to carry out its functions. Such staff are not public employees for the purposes of Chapter 110 or Chapter 112, except that the board of directors and the employees of the corporation are subject to the provisions of S. 112, 1061, and Part 3 of Chapter 112. The provisions of S. 768.28 apply to each such corporation, which is deemed to be a corporation, primarily acting as an instrumentality of the state, but which is not. An agency within the meaning of S. 20.03. Each corporation created to perform the functions provided in this section shall be a Florida corporation not-for-profit, incorporated under the provisions of Chapter 617, provide administrative, examination, licensing, investigative, and prosecutorial services to the board, which services may include unlicensed activity investigations and prosecutions. In accordance with the provisions of this chapter, the applicable Practice Act, and the contract required by this section, receive, hold, and administer property, and make only prudent expenditures directly related to the responsibilities of the applicable board and in accordance with the contract required by this section. Be approved by the department to operate for the benefit of the board and in the best interest of the state. and specifically authorized by the legislature, operate under a fiscal year that begins on July 1 of each year and ends on June 30% of the following year, be funded through appropriations allocated to the regulation of the relevant profession from the Professional Regulation Trust Fund pursuant to S 455.219. Have a 5-member board of directors, 3 of whom are to be appointed by the applicable board and must be licensees regulated by that board, and 2 of whom are to be appointed by the secretary and are laypersons not regulated by that board. Initially, 1 member shall be appointed for 2 years, 2 members shall be appointed for 3 years, and 2 members shall be appointed for 4 years. 1 layperson shall be appointed to a 3-year term, and 1 layperson shall be appointed to a 4-year term. Thereafter, all appointments shall be for 4-year terms. No new member shall serve more than 2 consecutive terms. Failure to attend 3 consecutive meetings shall be deemed a resignation from the board of directors, and the vacancy shall be filled by a new appointment. No professional board member may also serve on the board of directors for the corporation. Select its officers in accordance with its bylaws. The members of the board of directors may be removed by the governor for the same reasons that a board member may be removed, pursuant to S 455.209. Select the president of the corporation, who shall manage the operations of the corporation, subject to the approval of the board. Use a portion of the interest derived from the corporation account to offset the costs associated with the use of credit cards for payment of fees by applicants or licensees. Operate under a written contract with the department. Provide for an annual financial audit of its financial accounts and records by an independent certified public accountant. The annual audit report shall include a management letter in accordance with S 11.45 and a detailed supplemental schedule of expenditures for each expenditure category. The annual audit report must be submitted to the board, the department, and the Auditor General for review. Provide for all employees and non-employees charged with the responsibility of receiving and depositing fee and fine revenues to have a faithful performance bond in such an amount and according to such terms as shall be determined in the contract. Keep financial and statistical information as necessary to completely disclose the financial condition and operation of the corporation, and as requested by the Office of Program Policy Analysis and Government Accountability, the Auditor General, and the Department. Submit to the Secretary, the Board, and the Legislature on or before October 1 of each year a report describing all of the activities of the corporation for the previous fiscal year, which includes, but is not limited to, information concerning the programs and funds that have been transferred to the corporation. The report must include 1. The number of license renewals. 2. The number of license applications received. 3. The number of license applications approved and denied and the number of licenses issued. 4. The average time required to issue a license. 5. The number of examinations administered and the number of applicants who passed or failed the examination. 6. The number of complaints received. 7. The number of complaints determined to be legally sufficient. 8. The number of complaints dismissed. 9. The number of complaints determined to have probable cause. 10. The number of administrative complaints issued and the status of the complaints. 11. The number and nature of disciplinary actions taken by the board. 12. All revenues received and all expenses incurred by the corporation during the preceding fiscal year in its performance of the duties under the contract. 13. Any audit performed under paragraph, including financial reports and performance audits. The status of the compliance of the corporation with all performance-based program measures adopted by the board. Meet or exceed the requirements of the business case developed by the board and approved by the Executive Office of the Governor. The department shall annually certify that the corporation is complying with the terms of the contract in a manner consistent with the goals and purposes of the board and in the best interest of the state. If the department determines the corporation is not compliant with the terms of the contract, including performance standards, and measurable outcomes, the contract may be terminated as provided in paragraph. Nothing in this section shall limit the ability of the corporation to enter into contracts and perform all other acts incidental to those contracts which are necessary for the administration of its affairs and for the attainment of its purposes. The corporation may acquire by lease and maintain, use, and operate any real or personal property necessary to perform the duties provided by the contract and this section. The corporation may exercise the authority assigned to the department or board under this section or the practice act of the relevant profession pursuant to the contract, including but not limited to initiating disciplinary investigations for unlicensed practice of the relevant profession. The corporation may make a determination of legal sufficiency to begin the investigative process as provided in S 455.225. However, the department or the board may not delegate to the corporation, by contract or otherwise, the authority for determining probable cause to pursue disciplinary action against the licensee, taking final action on license actions or on disciplinary cases, or adopting administrative rules under Chapter 120. The department shall retain the independent authority to open, investigate, or prosecute any cases or complaints as necessary to protect the public health, safety, or welfare. In addition, the department shall retain sole authority to issue emergency suspension or restriction orders pursuant to S 120.60, or may delegate concurrent authority for this purpose to the relevant professional board. The corporation is the sole source and depository for the records of the board, including all historical information and records. The corporation shall maintain those records in accordance with the guidelines of the Department of State and shall not destroy any records prior to the limits imposed by the Department of State. The board shall provide by rule for the procedures the corporation must follow to ensure that all licensure examinations are secure while under the responsibility of the corporation, and that there is an appropriate level of monitoring during the licensure examinations. The contract between the department and the corporation must be in compliance with this section and other applicable laws. The department shall retain responsibility for any duties it currently exercises relating to its police powers and any other current duty that is not provided to the corporation by contract or this section. The contract shall provide, at a minimum, that the corporation provide administrative, examination, licensing, investigative, and prosecutorial services in accordance with the provisions of this section and the Practice Act of the relevant profession. The prosecutorial functions of the corporation shall include the authority to pursue investigations leading to unlicensed practice complaints with the approval of and at the direction of the relevant professional board. With approval of the department and the board, the corporation may subcontract for specialized services for the investigation and prosecution of unlicensed activity pursuant to this chapter. The corporation shall be required to report all criminal matters, including unlicensed activity that constitutes a crime, to the state attorney for criminal prosecution pursuant to S 455.2277. The articles of incorporation and bylaws of the corporation be approved by the department. The corporation submit an annual budget for approval by the department. If the department's appropriations request differs from the budget submitted by the corporation, the relevant professional board shall be permitted to authorize the inclusion in the appropriations request of a comment or statement of disagreement with the department's request. The corporation utilizes the department's licensing and computerized database system. The corporation be annually certified by the department as complying with the terms of the contract in a manner consistent with the goals and purposes of the board and in the best interest of the state. As part of the annual certification, the department shall make quarterly assessments regarding contract compliance by the corporation. The contract must also provide for methods and mechanisms for resolving any situation in which the assessment and certification process determines noncompliance, to include termination. The department employ a contract manager to actively monitor the activities of the corporation to ensure compliance with the contract, the provisions of this chapter, and the applicable Practice Act. The corporation be funded through appropriations allocated to the regulation of the relevant profession from the Professional Regulation Trust Fund. If the corporation is no longer approved to operate for the board or the board ceases to exist, all monies, records, data, and property held in trust by the corporation for the benefit of the board revert to the department or the state if the department ceases to exist. All records and data in a computerized database must be returned to the department in a form that is compatible with the computerized database of the department. The corporation secure and maintain, during the term of the contract and for all acts performed during the term of the contract, all liability insurance coverages in an amount to be approved by the department to defend, indemnify, and hold harmless the corporation and its officers and employees, the department and its employees, the board, and the state against all claims arising from state and federal laws. Such insurance coverage must be with insurers qualified in doing business in the state. The corporation must provide proof of insurance to the department. The department and its employees, the board, and the state are exempt from and are not liable for any sum of money which represents a deductible, which sums shall be the sole responsibility of the corporation. Violation of this paragraph shall be grounds for terminating the contract. The board, in lieu of the department, shall retain board counsel pursuant to the requirements of S 455.221. The corporation, out of its allocated budget, shall pay all costs of representation by the board counsel, including salary and benefits, travel, and any other compensation traditionally paid by the department to other board counsel. The corporation, out of its allocated budget, pay to the department all costs incurred by the corporation or the board for the division of administrative hearings of the Department of Management Services and any other cost for utilization of these state services. The corporation, out of its allocated budget, pay to the department all direct and indirect costs associated with the monitoring of the contract, including salary and benefits, travel, and other related costs traditionally paid to state employees. The corporation comply with the performance standards and measurable outcomes developed by the board and the department. The performance standards and measurable outcomes must be specified within the contract. Corporation records are public records, subject to the provisions of S 119.0, 7, and S 24. Art. I of the state constitution, however, public records exemptions set forth in SS 455.217, 455.225, and 455.229 for records held by the department shall apply to records held by the corporation. In addition, all meetings of the board of directors are open to the public in accordance with S 200 and 86.01(1) and S 24 Art. I of the state constitution. The department and the board shall have access to all records of the corporation as necessary to exercise their authority to approve and supervise the contract. The Auditor General and the Office of Program Policy Analysis and Government Accountability shall have access to all records of the corporation as necessary to conduct financial and operational audits or examinations. If any provision of this section is held to be unconstitutional or is held to violate the state or federal antitrust laws, the following shall occur. The corporation shall cease and desist from exercising any powers and duties enumerated in this section. The department shall resume the performance of such activities. The department shall regain and receive, hold, invest, and administer property and make expenditures for the benefit of the board. The executive office of the governor, notwithstanding Chapter 216, may reestablish positions, budget authority, and salary rate necessary to carry out the department's responsibilities related to the board.